Hello everyone, welcome to Lopez. Today I am here with a case in POCSO Act. It mostly applies in Section 41 of POCSO Act, that is immunity for the medical practitioners when the medical examination is done in the presence of the parents or guardian. Okay, so in the present case, what happens? So we are going to see the case in detail. Let's check out. So the case is Dr. C.M. Abubakar versus State of Kerala and others. So in this case, you can see Section 41 of POCSO Act was taken up and decided upon. So what is Section 41? It's an immunity for the doctors or the medical practitioners. So the examination done in the presence, immunity of medical procedures proceed performed with parental consent. So Section 41 of POCSO Act is an immunity of medical procedure performed with parental consent. So in this case also, you're going to see some sort of thing like that. So we move on to our case. Kerala High Court set aside a POCSO case against a pediatrician doctor who was alleged to have committed aggravated sexual assault on a 10th standard student during a medical examination. This is the thing we are going to see in this case. So, as you have heard, this is related to POCSO case. So, what is that? A child was taken to the doctor with the condition of chest pain, abdomen pain, and some sort of pain in the collarbones also. And there was a growth deficiency which was seen. So, she was advised to do scan and come back. So, when she approached the doctor for the medical examination, first, the mother was accompanying her. So the doctor, in the presence of the mother, examined the patient, that is the student. He took his hands and put inside and he pressed the chest as well as the abdomen in order to examine the patient. So, pressing of the doctor or the examination of the doctor was a bad touch as per the student. She felt as bad touch. She said this to her sister when she came back. So the next visit, the sister was accompanying her, but the sister said, this is not that. You just felt that was only an examination from the part of the doctor. But when the sister accompanied her for the next visit, the sister also saw the same procedure what her sister has narrated, the patient has narrated. She is saying in front of her. The doctor examined the patient. Same, he pressed the chest and the abdomen. So she also got annoyed, and the sister filed the case with police. And what has happened is that the complaint was filed with the police, and the statement also was given to the magistrate that she felt the move of the doctor as bad touch. So what has happened? The doctor was examining and the student felt is it as a bad touch. You cannot blame the girl for that, but the doctor was performing the duty also by examining the patient. So this is the two scenario. Both are right in their aspects. So what the case leads next. The police charged the doctor with section 354A, that is sexual harassment of IPC, and section 9 and 10 of POCSO Act cases, that is aggravated sexual assault. So what has happened? The doctor is in a great dilemma. So the doctor again approached the court regarding this, and what was the doctor's condition? The doctor approached the High Court to quash further proceedings in this case, saying whatever he has done was within the parameters of clinical examination. That is, I have done all the things which is my right. By examining the patient, I wanted to know what is her condition, her pain, the things what she was undergoing. I was examining and finding out the diagnosis. And you cannot, that was also what he also stated was that it was all the examination for the patient was all done in the presence of close relative of the child. That is, the close relative both were, one was the mother and the second was the sister. So the doctor's contention was that, and there was to cannot be said that any sort of sexual drive was there, or any sort of intention cannot be driven by all this. It was all a pure parameters of clinical examination. So, however, the High Court observed that it cannot conclude sexual intention from the casual remark alone. While checking all the things with both the parties, High Court also said it cannot conclude sexual intention. They cannot say that there was any sort of sexual intentions in this case because this is a casual remark. The court observed that offense of sexual assault in IPC or POCSO, it is very important to show that the act was committed with sexual intention. There must have a sexual intention to prove that. You should prove that there was a sexual intention from the part of the petitioner or the defender. What are the parties here? What are you defending the person? Okay, so they cannot find any sort of sexual intention. But it was also hard to believe that the petitioner was sexual, had made any sexual advances to the victim in the presence of mother and sister. So we can see that mother and sister are present in the examination room. The doctor is examining and they are seeing what the doctor is doing, and all sort of things, what the doctor is doing, what the diagnosis is making, and what the doctor is speaking to the child, or what he is hearing from the child, or everything they are also saying. And you cannot say there was any sort of sexual advances from the doctor. The court also noted that the victim had approached the hospital with complaint of chest pain and abdomen pain, and only after checking with the stethoscope the doctor proceeded to